Thank you, Professor. I want to sort of use that as a basis to launch into a sort of a conversation about it. And let me skip Ambassador Prosper for a second and go to Gabor. So it's a pretty provocative proposition, Gabor. What do you think? That we're just beyond where the law can reach, and that it's not sensible. In fact, maybe it's hypocritical to suggest that this is something that is or should be restrained by law, particularly for the boots on the ground. Your expertise in international humanitarian law may come useful here. What's your position on this?
Well, I think to an extent there's virtue in the idea that all law is to some extent aspirational. And that's equally true for domestic law. We don't throw the laws against murder off the books, and we don't retire our police forces simply because murder persists. And the scope of and the role of international law, and particularly international humanitarian law, but just as well international human rights law, is somewhat similar. There are rules. To the extent those rules are enforceable, they should be enforced. And in fact, we have treaty obligations. For example, under the Geneva Conventions, states that are party are not only obligated to obey the rules of the conventions, they solemnly swear to do that when they become a party to the convention, but they are also obligated to ensure respect for the conventions. Likewise, states that are parties to international human rights treaties, as the United States is, have obligations, for example, under the International Convention on Civil and Political Rights, not only to obviously obey the rules, but to provide remedies for the violations of those rules. Likewise, states that are party to the Torture Convention, as the United States is, have obligations to provide remedies for the violations that occur of those conventional obligations. So I think that in essence, it's really of no use to say it is war, therefore there are excuses that can be made for the lack of application of the rules, because states, including the United States, have solemn obligations to abide by the rules and to provide for remedies when the rules are broken. And that's precisely where the courts come into play. When a treaty requires that a state provide a remedy for a person who has been tortured, then isn't the court exactly what we're talking about? And in situations where the Geneva Conventions require that a state try or extradite someone who is suspected of or can be charged with grave breaches of the convention, then the convention itself is speaking precisely to the question of the role of the courts and is demanding judicial enforcement. So I think the idea that courts have a role in dealing with aspects of armed conflict, dealing with aspects of violations of human rights that occur in times and situations of armed conflict should not be controversial, and is not controversial to, I think, anyone who takes seriously the obligations that arise from becoming a party and being a party to the international treaties such as the Geneva Conventions, the Torture Convention, the International Covenant on Civil and Political Rights.
Ambassador, let me get your involvement here and get your thoughts on something. Professor Jones mentioned the experience in Vietnam. No question, there was the Phoenix program, which is something that many people on this audience may be familiar with. There was torture in Vietnam, and that happened despite the fact that every serviceman in Vietnam and women were given a card which read, titled "The Enemy in Your Hands," and the card included these admonitions. As a member of the U.S. military forces, you will comply with the Geneva Prisoner of War Conventions of 1949 to which your country adheres. You cannot and must not mistreat your prisoner, humiliate or degrade him. You cannot take any of his personal effects which do not have significant military value. You always will treat your prisoner humanely. And on the back of the card there was a quote from President Johnson which said, "The courage and skill of our men in battle will be matched by their magnanimity when the battle ends." And so the abuse took place in spite of the official declaration that the conventions apply. Ambassador, do you think that there is a difference between abuse that takes place in spite of or in the absence of the conventions? In other words, does it make any significance that the position was, post 9/11, that the conventions would not apply?
Well, it's my view that we, the United States, or any government, needs to follow the rule of law. We need to take every step that we can to try to achieve the various principles that exist. And if a decision is made by either an individual or a government to not follow what is clear law, then that's a decision that someone makes at their own risk, and then they expose themselves to whatever legal liability exists. So in other words, someone could make a policy decision or a decision to let's say, torture an individual because they feel, he or she feels that that's what's needed at that moment to extract information. My view is, okay, if you do that, you must then be prepared to pay the consequences. And let as you say, if this is a situation where you go before the court, be it a military court or civilian court, the court will then decide whether or not there were some sort of mitigating factors there. But I think it's important that we don't just move the law to the side and say, well, it doesn't apply in this situation. So we have to ensure that the law applies. In a situation of post 9/11, I think arguments were made that maybe there was an absence of law, but I think it's the situation was muddled, and it was, as I was saying earlier, it was a question of what law actually applies. So there were people that were operating in good faith in that arena, and there may have been people in certain situations that, despite the fact, as you say, of the existence of the law, they chose to take a particular course of action, which was wrong, and need to be held to account. Because